I'm Jeffrey Rosen, President and CEO of the National Constitution Center, and welcome to We the People, a weekly show of constitutional debate. The National Constitution Center is the only institution in America chartered by Congress to increase awareness and understanding of the Constitution among the American people. And this week, we're recording We the People live in front of the National Constitution Center audience for the first time. Friends, let's have a round of applause for our We the People audience. It is so exciting to see our great friends here at the National Constitution Center and to share this learning with you and with our We the People audience. Here in Philadelphia, we're previewing the Supreme Court's October 2019 term, which begins next Monday, October 7th. And I'm so excited to be teaming up with the podcast SCOTUStalk to preview the blockbuster cases of this term. We're joined by two of America's leading court watchers for SCOTUS Blog. Amy Howe co-founded SCOTUS Blog in 2002 and was editor and reporter there until 2016. She continues to write for SCOTUS Blog in addition to writing her own blog, Howe on the Court. Amy served as counsel in over 24 merits cases at the U.S. Supreme Court and argued 2 cases there. She's also taught at Stanford, Harvard, and several other law schools. Amy, thank you so much for joining.
Thanks for inviting me. It's great to be here.
It's wonderful to have you. And John Elwood is a contributor at SCOTUS Blog, where he writes the Relist Watch, monitoring cases that the court has relisted. He is a partner at Arnold & Porter in Washington, D.C., where he heads the firm's appellate and Supreme Court practice. He has argued 9 cases before the U.S. Supreme Court and has argued before most of the federal courts of appeals. John was senior deputy in the Justice Department's Office of Legal Counsel from 2005 to 2009, an assistant to the Solicitor General from 2002 to 2005, and an attorney in the department's criminal division. John, it is wonderful to have you on the show.
Thank you for having me.
Amy, let us start with you. Last year was something of a blockbuster term with powerful cases at the end involving the census and partisan gerrymandering. At the same time, there was a high degree of unanimity on Justice Brett Kavanaugh's first term. What are you expecting from this term? Will it be a blockbuster or sleepers? And where are the fault lines likely to be?
I think it's going to be even more of a blockbuster than last term. We had certainly big cases last term. In the census case, there was a big case in partisan gerrymandering. But the conventional wisdom, at least, was that last term, the Supreme Court was actually trying to keep a relatively low profile, including because of the contentious confirmation hearings of the court's newest justice, Brett Kavanaugh. And so we saw, each of the court's more conservative justices at some point during the term sort of crossed over and voted with the court's more liberal justices. And we also saw them sort of, for lack of a better word, kick the can down the road in a couple of cases. Some of the cases that we're going to be talking about tonight were actually cases that the Supreme Court could have heard oral argument in and decided last term, but for whatever reason decided not to. And so the Supreme Court's going to have a lot of blockbuster cases, including some that we're going to talk tonight, and we're really going to hit a lot of the hot button issues. It's already got LGBT rights, immigration, guns, and it almost certainly is going to have abortion on its docket. And it's going to be issuing all of these decisions. If it had been trying to keep a low profile last term, the result is it's going to be issuing all of these decisions in the spring and summer of 2020, right in the middle of the presidential election season. I think the justices are also probably at home watching cable news like the rest of us and crossing their fingers that none of the legal disputes related to impeachment or records, come to the Supreme Court. They would have to weigh in.
Wow, thank you for whetting our appetites
yes,
so well.
Exactly.
Both the exciting Supreme Court term and this incredibly important discussion we're about to have. John, Amy mentioned the unexpected alliances last term. She noted that Justice Gorsuch and Justice Kavanaugh voted together less frequently than any 2 justices appointed by the same president in the past 50 years, and suggested that this term is likely to be even more dynamic. How do you see the fault lines on this term, and do you think it will be a blockbuster or not?
No, I agree with what Amy said across the board, but they are very different. Although they were appointed by the same president, they're very different justices. We'll get a better sense of that next term because, anytime you're dealing with so few cases, the court takes around 70 cases a term, it's hard to know if what you're seeing is a trend or just noise. But they are very different people. We saw a little bit of that last term, and I expect we'll probably be seeing more of it in the coming term as well. Gorsuch is more of an iconoclast and kind of a maverick, although you hate to use a term that so plays into sort of the Western upbringing. And Kavanaugh is more kind of a centrist. Gorsuch dissented more than anybody last year, and Kavanaugh was in the majority more than anybody last year. And it'll be interesting to see if that trend continues. I kind of suspect it will.
Fascinating. Thank you for putting it so crisply, and that's a memorable way of distilling the differences among these two justices. All right, we must plunge right into the docket because there are such important cases, and we begin with LGBT rights. The first week in October, the court will hear 3 cases involving the question of whether Title VII's prohibition on discrimination because of sex includes sexual orientation. In 2015, for the first time, the EEOC said that discrimination because of sex did encompass discrimination because of sexual orientation, and the court will decide whether or not that was correct. Amy, tell us about the facts in the 2 cases involving 2 individuals who say they were fired because they were gay. That's the Altitude Express case and the Bostock case, and the arguments for and against viewing that kind of discrimination as discrimination covered by Title VII.
Sure. So the first case is a case called Altitude Express versus Zarda, and the employee in this case was a man named Donald Zarda, who's actually passed away. He was a skydiving instructor, and as part of his work, so frequently, he was a skydiving instructor who'd be sort of strapped to one of his clients before they jumped out of a plane together. And sometimes he said to reassure his clients when they were women that he wasn't trying to get too friendly with them, he would tell them, "I'm gay." And so he said this to someone, and after he said this to someone, then later on he said he was fired because he was gay. And so he sued the company for discrimination. And sort of under federal law, this is the law that you have to rely on if you want to argue that you were discriminated against, if that you were fired or didn't get a promotion because of your sexual orientation. The other employee in the case was a man named Gerald Bostock, who worked for Clayton County, Georgia, and argues that he was fired because he was gay. And it hinges on the interpretation of this statute, Civil Rights Act of 1964, and the phrase "because of sex," and everyone, I think, in the case agrees that when Congress enacted this language in 1964, it wasn't thinking about discrimination based on sexual orientation. But there was a 1998 decision by Justice Scalia. It was actually a unanimous decision in a case called Ancale. The Supreme Court in that case ruled that you could rely on the Civil Rights Act to bring a lawsuit for discrimination, same-sex sexual harassment. And the key part, which I think will play a prominent role of the oral argument, Justice Scalia said, is that it doesn't really matter what Congress had in mind when it wrote the language of Title VII. All that really matters is the text itself. And so the argument that the employees are making is that when you refer to discrimination because of sex, is that they are being discriminated against because they are men who are attracted to other men. That if they were men who were attracted to women, they would not have been fired.
Thanks so much for that, and for putting the arguments in favor of the 2 men so well. John, the employers in this case disagree, and they advance a bunch of propositions for why sexual orientation should not be covered by Title VII. Tell us what those arguments are.
Well, this case is a very good illustration. It's going to flesh out Justice Kagan's statement that we are all textualists now, because the primary arguments in this case are textualists, both from the employees and the employers. And the employers take a slightly different view of the textual arguments, because they say, we're not firing anybody because they're a man or because they're a woman. It's not because of their sex. It's because of who they're attracted to. It's because of sexual orientation, and that is not sex. And that they fall back not on kind of a mechanical application of man dating another man. That's because of sex. And they say the original public meaning back in 1964, nobody would have said if you fired someone because of their sexual orientation that it was discrimination on the basis of sex, or you were firing them because of their sex. It's because of sexual orientation. And that under the sort of original public meaning, as they say, it is not discrimination. And they further say that even though you talk about as this on-cal, I don't know how it's pronounced either.
I was on the panel, we pronounced it 3 different ways. So.
But I'll call it sundowner then, that was
Yes.
the respondent. We can all agree on how that's said. But that even if you don't look to what the evils are, it's one thing to say you're going to sweep in ancillary things. So if Title VII covers harassment, it also covers same-sex harassment. It's another thing to sweep in an entirely new area of the law, which is a pretty considerable thing, and which Congress and other legislatures have talked about regulating discrimination separately. It's another thing to sweep that in entirely. There's this kind of doctrine that Congress doesn't hide elephants in mouse holes. And you can say, it's one thing to say same-sex harassment, we're going to sweep that in with opposite-sex harassment. But it's another thing entirely to sweep in sexual orientation. You might want to regulate that differently. You might want to exempt religious organizations or religious employers. So leave this for Congress.
Thank you very much for that, and for emphasizing that the employers say that Congress, no reasonable person in 1964 would have assumed that because of sex, prohibited discrimination because of sexual orientation. And the employers also stress, as you say, that Congress has refused on several occasions since '64 to add sexual orientation, and that while 22 states have added the prohibition, most have not. During the first week in October, the court will hear a separate case involving transgender rights. And that raises related but different arguments about whether discrimination on the basis of gender identity is discrimination because of sex. Amy, tell us, please, about the facts in the R.G. and G.R. Harris Funeral Homes case and what the argument in favor of recognizing discrimination on the basis of gender identity as discrimination because of sex is.
So as you said, it's similar although not identical. The employee in this case had been hired by the funeral home as presented as a man, and then one day sent a letter and said, I'm going to be coming to work dressed as a woman. My name is going to be Amy Stevens, and eventually I'm going to have gender reassignment surgery. The owner of the funeral home was very religious. There's also a lot of discussion about a dress code that the funeral had, that the men were supposed to wear suits to work every day. The funeral home provided an allowance to buy these suits. And the owner of the funeral home said, this really just doesn't comport with either my beliefs as a Christian or the dress code and how I'd like you to present to the public. And so the employee, Amy Stevens, was fired. So Amy went to the EEOC, the Equal Employment Opportunity Commission, which filed a complaint on her behalf. And it's a little bit of an interesting twist here because originally the EEOC was on her side, believing that she could bring a complaint under Title VII of the Civil Rights Act. But as the case comes to the Supreme Court, the Trump administration is now arguing that there is no right to bring a claim under Title VII based on discrimination, based on gender identity. So that's a little bit of a shift by the federal government. But so the arguments are similar in the sense that Amy Stevens' argument in the Supreme Court is, you would not discriminate against me if I were a woman who presented as a woman, but you're discriminating against me or if I were a man who presented as a man, but was assigned the gender of a man at birth, and now I'm presenting as a woman. And then there's a separate claim that's not a separate claim in the case based on sexual orientation involving what's known as sex stereotyping, the idea that you can't discriminate based on your idea of what a woman should look like or what a man should look like. And it was a case called Price Waterhouse, in which a partner in an accounting firm hadn't gotten a promotion, she said, because she was, didn't dress feminine enough. She was too aggressive, they said. And so the idea is that when you are discriminating based on gender identity, when you are when you believe that someone who is transgender is not complying with your idea of what a man or a woman should look like.
Thank you very much for that. So as you've explained, two of the arguments are similar and related in both cases. The but-for argument is the same, but for the fact that Amy Stevens was born as a male. She's arguing she wouldn't have lost her job for wanting to present as a female. And then there's the sex stereotyping argument under this case, Price Waterhouse, you just identified, where she says discrimination because of transgender status is motivated by sex-based stereotypes. John, you suggested that the more textualist justices might be skeptical of those arguments about sex-based stereotypes. Is it possible that a textualist justice could view sexual orientation differently than gender identity, viewing transgender status as more closely identified with a person's sex than sexual orientation?
That's a tough one. I mean, it's, the cases are so similar in some ways, but I mean, to me, the transgender case does seem to revolve more around sex stereotyping is a more kind of obvious way of them to win that case. And because the sex stereotyping argument, to me, is a little bit less moored to the text, I could see it kind of running into more trouble with the more conservative justices. I think, especially like Justice Gorsuch, he had a case where he ruled for the employee last term or the term before, I forget which one it was, in an arbitration case, because he took a originalist view, original public meaning view of what the word employee meant, which at the time the statute was passed would have encompassed independent contractors, and so in that case the employee won. But in this case, I think, if he looks at the original public meaning, that could have a very different outcome for the employee. I think that the place that the justices who the employee is most likely, Amy Stevens is most likely to pick up, are probably the Chief Justice and and Brett Kavanaugh. We'll see. I think that they're probably the most available votes of the more conservative voters. And it'll be interesting to see which way they go. One thing I have to note as a totally non-germane aside, there was a criminal defendant, I think, in a case a few years back who was transgender, and Justice Alito managed to write the entire opinion about this defendant without ever using a pronoun. And it'll be interesting if he tries to repeat, I don't know if he'll have an opinion in any of these cases, but it didn't jump out at me when I read it. It was only when somebody pointed it out to me that I noticed it. But it'll be interesting if anybody tries to repeat that verbal trick this time.
Just one more beat on this, Amy, because I'm always urging we, the people listeners, not to assume that votes correlate with the presidents who appointed justices, but correlate more with their constitutional and statutory methodologies and philosophies. John just said that the Chief and Justice Kavanaugh might be votes that the Amy Stevens could get. Do you agree? And what methodologies would lead the Chief and Justice Kavanaugh to vote for Amy Stevens in this case if they did so?
I think that the sex stereotyping would be sort of the hook there. I think that I'm actually also going to be watching Justice Gorsuch closely during the oral argument. I think of him as sort of the successor to Justice Scalia, who wrote the opinion in the Ancale case. And I can see a scenario in which he looks at Ancale and says, Title VII, the phrase because of sex, that's not what Congress had in mind, but I think you can read it that way.
That's true. And John, it's fascinating tension between textualism, which says just look at the words and not at the original public meaning, and a focus on legislative history, which Justice Scalia eschewed, but at least in this case would point against ruling for the people who are seeking protection. John, how might that split between textualism and legislative purpose break down, and could it create some unexpected alliances?
Well, I think the employers are trying to dress up sort of legislative history and congressional intent, which are kind of out of favor with original public meaning is the way it is kind of phrased. But it is still, they're arguing it's a form of textualism, and you're looking at how people at the time would have understood the words. And it's extremely hard to predict how it's going to shake out. Personally, I sort of feel like Justice Gorsuch is unlikely to embrace a reading that says that discrimination on the basis of sexual orientation or transgender status is covered. But all of these cases, you don't kind of really know what's going to happen until a couple of points. The first is during oral argument when you see what people's questions are like, and then I think the easier time to predict it is when the opinion is actually issued. You can just see the way it came out because I've been surprised as often as I've felt like it bore out my understanding after argument.
You do have to read the entire opinion, though, because
you don't even know that. That's true, yes, until you get to the last page.
Absolutely. Our next blockbuster case also involves a reversal between the administrative determinations of the Trump administration and the Obama administration with huge consequences. It involves the DACA and DAPA programs. Those acronyms are the Deferred Action for Child Arrivals and the Deferred Action for Parents of Americans in Lawful Permanent Residence. The Obama administration had tried to forbear seeking the removals of certain aliens brought to the United States as children. The Trump administration tried to reverse that policy. Amy, tell us about that reversal and what the legal challenges to the Trump administration's attempt to reverse the policy are.
Okay, so this is a trio of cases at the Supreme Court challenging the Trump administration's decision in 2017 to end the program known as DACA, Deferred Action for Childhood Arrivals. The decision to end DACA, when it was announced, was immediately subject to challenge. And a couple of different lower courts around the country ruled that the Trump administration could not terminate DACA. The challenges were based on two things: the idea that it violated the Administrative Procedure Act, which is the laws governing how the federal agencies and federal government can act, and then that it violated the rights of DACA recipients. And so the lower courts agreed. They said that the decision was known as arbitrary and capricious. It wasn't the product of reasoned decision making. So the Trump administration took it straight to the Supreme Court without stopping in the lower courts. And the Supreme Court agreed to weigh in June of this year. And so there were two questions before the Supreme Court. And the first is whether or not the Trump administration's decision to end the DACA program is something that courts can review at all. The Trump administration, as you might expect, says no, it's not, because this is something that's within our discretion. We've got this program, we want to end it. It's sort of a political decision that courts should stay out of. The challengers say absolutely it's something that courts can weigh in on. And the reason they can weigh in on it is because the reason that the Trump administration said it wanted to end DACA was because it thought that DACA was illegal. And so that's not a discretionary decision if you're saying that it's a program that violates the law. So the first question is whether or not the courts can weigh in at all. If the Supreme Court decides that it can weigh in, then the next question is whether or not the decision to end DACA was in fact illegal. The Trump administration says yes. It was not illegal. We thought it was unlawful, and besides that, there are a whole host of other reasons why we wanted to do it. And in particular, we believed, based on the court's ruling on the DAPA program, the Deferred Action for Parents of Childhood Arrivals, that it was likely to be struck down at any moment, and we wanted to go ahead and do it on our own terms rather than have some court tell us we had to do it now. And the challenger's response is, you only told us one reason at the beginning why you wanted to do it. You thought it was illegal, and you can't. That's not the case. It's not illegal, and you can't bring in all of these other reasons after the fact to justify it. Essentially, is what the arguments boil down to.
Beautifully described. Thank you so much for doing it so clearly. John, maybe begin with this question of the arguments for and against whether DACA and DAPA are in fact illegal. The Supreme Court, during the year when there were only 8 justices after Justice Scalia passed, divided 4-4 on that question. What was the division there, and what is the relevance of that division for the two questions that Amy so well set out?
Well, You don't get to find out when they divide equally who was where, really, but I presume that it was on the standard liberal conservative lines, which means that everybody is looking at Justice Kavanaugh to see how it would come out this time. And so I guess everyone will be looking at him for this case.
Thanks so much for that. So John, Amy identified these two arguments. Can the court review it, and is the program actually illegal? What are the arguments against the court reviewing it and the arguments against the legality of these programs?
Well, the argument against the court reviewing it is that there's basically no law to apply. And the administration is in kind of a tough position when they were just relying on their argument that we think this program is illegal. And that's the reason why we're dropping it, because that's something where there is law. They can look at that. That's the second question, after all. And that's why I think the administration is trying to fold in other arguments, this idea that, look, it's subject to litigation risk, and so we just want to, wrap things up. And also, we want to communicate the idea that, undocumented border crossing is wrong. Because that's, those are arguments for exercising discretion. And I think nobody thinks, people think generally speaking that if the administration were willing to take a hit and say, yes, we just want to end this program because we're against it, that, it's a discretionary, it's an exercise of discretion, and that's kind of a traditional thing that agencies, isn't really all that reviewable. And I think that's one of the reasons why, they have improved their argument by trying to fold in these additional considerations. But the problem is, as Amy indicated, that there's this principle of administrative law, the Chenery Doctrine, that you have to evaluate administrative action according to its actual stated rationale. And you look at the time of action to do that, and so they might not be able to take advantage of these arguments they've developed along the way.
Thanks for that. Amy, there are big stakes in this case. The fate of nearly 700,000 DACA recipients is at stake. And tell us about the practical effects of a decision one way or the other, and also tell us about how this fits into the debate on the court about whether justices should defer to administrative agencies. Last term in the census case, the more conservative justices generally were inclined to defer to the president's decision to remove the citizenship question from the census. The liberal justices, joined by Chief Justice Roberts in this case, were less inclined to defer. Here, deference would rule against the administration, and how is that likely to play out?
Yeah, so the stakes, as Jeff mentioned, are high. And you've got over 500,000 of the term is dreamers who have applied or would have been eligible to apply for protection from deportation. And so there's the assurances that you are not going to be deported from the country, and then the protection also would, under DACA, also opened up other benefits, being able to apply for driver's licenses, being able to work legally in the United States, often being able to get health insurance. And so the stakes are quite large. As far as deference, I think that it will be interesting to see whether or not there are parallels to the census case in this oral argument. The census case, the Supreme Court, there were several justices who were willing to really let the Department of Commerce do an awful lot of what it wanted to do, but when push comes to shove, the message was you have to tell us the actual reason why you're doing it. And so it'll be interesting to see how this carries over into the DACA case. I'm inclined to say that the census case was really kind of a one-ticket-only decision. I think that the circumstances were so extreme in the sense that you had sort of this ongoing trickle of news coming out over as the Supreme Court was trying to decide the case about what was actually going on behind the scenes in the census case and what the real motivation for adding the question might have been. And so that may well have been the Supreme Court saying, we'll give you a lot of deference, but we're not going to let you do whatever you want.
Thanks for that. John, the conservative justices led by Justice Gorsuch are skeptical of the Chevron doctrine, which generally says courts should defer to administrative agencies unless its legal conclusions are plainly wrong. Justice Gorsuch thinks that courts should evaluate the law as an original matter and not be as deferential. Do you expect them to maintain this general refusal to defer in this case, and which way would that cut?
There is a rising tide of skepticism to administrative action generally. In this case, I'm not sure whether it'll get traction here. It may, because so much of this depends on whether the DACA program was illegal, and that is something that the courts are more expert than agencies on. So it may be that that they go straight to this legal issue and don't get too caught up in sort of matters of deference. But I candidly, I'm not really sure how that will shake out here. My gut instinct is that it's not as implicated here as it is in some matters.
Thank you for that. Our next topic is the free exercise of religion. There is an important case called Espinoza against Montana Department of Revenue, involving the extent to which the free exercise clause of the First Amendment forbids a state from refusing to provide certain benefits to religious organizations which it provides to secular organizations. Amy, tell us about the stakes in that case and the legal arguments.
This is a really interesting and potentially very important case. What it boils down to really are school choice programs. The Supreme Court has said that states can provide school vouchers, including for religious schools. And the question really that is could flow from this case is whether or not, if states provide aid to attend private schools, whether or not they're going to have to provide it so that people can attend religious schools as well. Back in 2015, the Montana legislature created a program that provided a dollar-for-dollar tax credit. If you donated to a scholarship program, you'd get a tax credit of up to $150, and those scholarship programs could then turn around and give people scholarships to attend private schools, including religious ones. And it turns out that in Montana, almost all private schools are religious ones. A little interesting tidbit was that the governor is Steve Bullock, who had vetoed similar bills several times, but ultimately let this one go without signing it into law because he was afraid that then there would be a referendum that would bring out lots of Republican votes, and so he just sort of let it pass. But so shortly after the bill was enacted, the Montana Department of Revenue passed a rule that said, yeah, this is all well and good, but our state constitution prohibits aid from going to churches and religious schools. So this program is in place, but you can't use it for scholarships to religious schools. And so this was quickly challenged by a group of parents who wanted to use the program to get scholarships to send their kids to Christian schools in Montana. The Montana Supreme Court didn't get into the constitutionality of the rule and instead said that struck down the whole program, said that under our state constitution, we can't provide aid to religious schools. The challengers had argued essentially that having this rule that barred aid from going to religious schools violated the federal constitution, which guarantees the free exercise of religion.
So I'm hearing you say there are competing precedents on the table. In the Zellman case, as you noted, the court upheld school voucher programs on the grounds that as long as parental choice rather than state control determined whether a secular or a sectarian school got the voucher money, it was consistent with the free exercise clause. Then we had the Locke v. Davey case, which reached a different conclusion. It said that a state program that gave need-based scholarships to attend religious or secular colleges, but excluded those who wanted to prepare for the ministry, was okay because it was, in that case, the money would have been going directly to the ministry. And then there was the Trinity Lutheran case recently that said that it was a violation of the free exercise clause to give assistance to secular schools but not religious schools for public funds like resurfacing the rubber on a school playground. So John, with these complicated precedents on the table, does it all boil down to whether that Locke v. Davey case is basically an exception for money that goes directly to the ministry, and otherwise, as long as the parents rather than the state is determining the direction of the fund, the court will generally uphold it? Or is there some other way of skinning this cat?
You know, it'll be interesting to see how the court handles it, because Locke is kind of a wrench in the works in that it kind of points in the opposite direction. There might be narrow ways of distinguishing it, because I believe that the money more or less went directly from the state to the person, to the student. So it was one step closer, because here it's basically you get a tax credit for contributing to a private fund. So there's like an additional kind of layer of, there's kind of an additional kind of step between the state and the religious institution here. And it may be that they think that's enough. But it's very hard to predict exactly what they'll say. I mean, the way the Roberts Court generally does things is that they're going to try to avoid overruling stuff if they can avoid it. And so they'll probably, say that is sufficient ground, assuming they're going to go out and rule in favor of the scholarships, that is an adequate basis for distinguishing it. But, when you take a step back, that was a Rehnquist, Locke versus Davey was a Rehnquist era court. It was in the waning days of the Rehnquist era court, which was, kind of more muscular federalism, and wanted to give states different ways of handling matters on their own. And that in the kind of intervening years, they've been focused more on kind of strict neutrality towards religion and treating religion like every other entrance. So it's kind of an interesting movement in the court in terms of, not to be too flippant, but it was much more kind of a flavor of the week and the Rehnquist court, the federalism, and now kind of strict religious neutrality is more of a feature of the Roberts Court.
That is a crucial principle of the Roberts Court, as you say, and religious neutrality has been getting the votes of 6-3 or 7-2 justices. The two, often Justices Ginsburg and Sotomayor, will take a more separationist position, as they did in the Bladensburg Cross case last year, where the other 7 justices said it was okay for historical reasons to keep the cross on what was now public land. But the Trinity Lutheran case was a lopsided one as well. So given all that, Amy, is this case likely to be a lopsided win in favor of religious neutrality and the voucher program? And if there are any divisions, might it be under whether to strike down these so-called Blaine amendments, which hold that any mingling of public and secular funds is impermissible?
I think it's likely to be closer, or at least more closely fought. The Trinity Lutheran case actually was really fascinating, because there was a pretty big gap between when the court announced that it was going to hear the case and when it was actually argued. And we don't know exactly what was going on behind the scenes, but every month would release the argument calendar, and it wasn't there. And sort of the sense was that it was after Justice Scalia died, that the uncertainty about when there was going to be a replacement, that was that they were waiting for a ninth justice, because they thought it might be a close call. When they finally got Justice Gorsuch, they heard the oral argument, and even after the oral argument, it didn't seem like it was going to be particularly close, but there was a sort of a key footnote in the Trinity Lutheran case that said essentially, this is about playgrounds. We're not talking about funding for religious uses. And at least a couple of the more conservative justices, I think Gorsuch and Thomas, said, basically, I think that was a footnote that they had to include to bring Justices Kagan and Breyer on board. But Justice Gorsuch and Justice Thomas, I believe, kind of balked at that footnote. And so, this is going to be a more difficult one. You can't say this is just about rubber funding for playgrounds. I think there may be ways to distinguish it, to sort of come up with an opinion that is has some sort of narrow compromise, the way that they had with the Bladensburg Cross case, in which Justices Breyer and Kagan joined some of the court's more conservative justices to say, well, at least when you have a cross on public land that's been there for almost a century and has another meaning besides just sort of endorsing Christianity, those crosses can stand. It's harder to see sort of what the compromise decision would be in this case right now, at least.
I'm so glad you called attention to that footnote, which shows the division on the court. John, do we have any sense of Justice Kavanaugh's views on religion cases? Would he be likely to join the moderate footnote saying that case was just about playgrounds, or is he more likely to side with Justices Thomas and Gorsuch in a broader opinion for religious liberty? And can you imagine a compromise position here, and what would it look like?
I think that the best proxy for Kavanaugh's vote is Chief Justice Roberts. They voted together. They were very close analogs last term. And although, of course, again, what I said before, we've only had a few cases from them, and it's very hard to generalize. But let me generalize anyway. That I think that they probably, I think that they're probably going to be voting more closely. So I think he's also very practical, and so I think he's going to be looking for kind of practical solutions. This is kind of a weird enough case. I mean, the fact that the Supreme Court reached out, I can't say reached out, they granted the petition even though they struck down the whole program. There was no discriminatory treatment, nobody was getting the program. There's enough weird things about the case that I sort of feel like Amy, that it doesn't feel like they're going to be able to cobble together a majority, but they are they all seem to be very motivated to not make cases look like they're breaking down on the lines of which president appointed them. So I think that they will look for what common ground they can find. But what common ground there is not always obvious.
Thanks for that. All right, one more merits case, and then we turn to the shadow docket and the cases the court has not yet agreed to hear but may, including abortion. The final case involves the Second Amendment. We did a great podcast on this fascinating Second Amendment case recently, but the case may become moot. In other words, the justices may soon decide that there's no longer a live controversy and dismiss the case. And yet there's at least one more Second Amendment case bubbling up that the court might take instead. So Amy, tell us about New York State Rifle and Pistol Association, why it might become moot, and what the stakes in the other Second Amendment cases that are bubbling up are.
Sure. So this is a challenge to a New York City law that prohibited, and I'm talking about it now in the past tense, even if you had a licensed handgun, prohibited you from taking it outside the city, including to your country home outside the city, or including to shooting practice at a target range outside the city. And so the New York State Rifle and Pistol Association challenged it as a violation of the Second Amendment. The Supreme Court agreed to take the case earlier this year, and it was the first time in almost 10 years that they had agreed to take up a Second Amendment case. So that in and of itself is noteworthy, because they'd had many requests to weigh in on various Second Amendment challenges to gun control laws and had declined to do so. This summer, New York City changed its rule so that the restriction no longer applied, and then New York State also changed its laws in a way that would sort of backstop the change to New York City's rule. And so New York City filed a motion with the Supreme Court to dismiss the case as moot, to say it is no longer a live controversy. The New York State Rifle and Pistol Association has resisted that move, saying that New York City, basically we don't trust New York City. They could change the rule back at any moment as soon as you dismiss the case, and you shouldn't trust them either. And in any event, they've changed the rule, but there are still violations of our right. If you're you can take your gun to your country home or to your target practice, but if you stop for coffee, that's a violation of the rule. And if you rent rather than own your summer home, it's also a violation. And so that the Supreme Court actually considered today whether or not they're going to hear oral argument in the case or instead dismiss the case. So we should know possibly by the end of this week, or more likely next week, what the Supreme Court's going to do. It has been scheduled for oral argument in December, but there are, even if this case were to go away, there are other challenges in the pipeline, so to speak, to different gun control laws, including a challenge to a New Jersey law that, among other things, if you want to get a permit to carry a gun, requires you to show a need to have the handgun. There are several states, I think, including Maryland have similar laws, and it's been a topic of several challenges at the Supreme Court. And the Supreme Court so far has not weighed in on them, but perhaps the Supreme Court is now more likely to consider them seriously.
Fascinating. John, it sounds like these need to carry a handgun laws are more common than New York's relatively unique law saying you can't carry a gun out of state lines to a firing range. If the court were to hear the need to carry laws, how would it evaluate it? And I learned from our last podcast that there's a division on the court between Justice Thomas and some other justices who believe that the court has relegated the Second Amendment to a second-class right and want to increase the level of scrutiny with which gun control laws are evaluated, and other justices who believe that the court got it right in the Heller case where it said that reasonable regulations are permissible. So how might the different justices evaluate a need to carry case if they took it up?
Well, as Amy says, it's been 10 years since we've heard anything from the court. And there have been a number of changes in the court's composition since then. And I think, unless you want to talk about the quartering clause, it's the Third Amendment of the Constitution, the Second Amendment has had so little written about it that the kind of scope of what it means is still very unsettled. So I think it would be very tough to say how the justices would interpret the Second Amendment and how it would apply to these kind of need to carry or need to carry laws. You have some general inklings about how they might approach it. Because Justice Gorsuch is a very kind of a fire-breathing originalist. Justice Kavanaugh views himself as an originalist, but he's kind of less outspoken about it. They're among the more important additions, especially when you consider that Justice Kavanaugh replaces Justice Kennedy, who was kind of putting the brakes. If you've read the various books that have been written since then, including Justice Stevens. Justice Kennedy was kind of putting the brakes on the court's past Second Amendment cases, suggesting that, we need to have an area for reasonable regulation. And it's a bit uncertain. As I say, Justice Kavanaugh, we have the impression that he's kind of more of a pragmatic person. But I think people correctly view him as being more conservative than Justice Kennedy. So it remains to be seen, what the Second Amendment is going to look like going forward.
Thank you for that. All right, our last rounds involve the so-called shadow docket, and the cases that people are looking at most avidly involve abortion. So Amy, what is the shadow docket, and what are the abortion cases that the court might hear?
So the shadow docket is sort of a loose term for the cases that aren't argued on the merits in open court and decided at the Supreme Court. So it can be sort of the cases in which the Supreme Court may or may not decide whether to hear them on the merits. And frequently, especially more recently, the Trump administration has come to the Supreme Court a lot, asking it to step in and block lower court orders, and the justices will act on those requests. But abortion is a case that is an issue that's in the pipeline and was considered at the Justices Conference today, and in fact, cases from 2 different states. There was a challenge to a Louisiana law that is very similar to a Texas law that the Supreme Court struck down in 2016 after the death of Justice Scalia. It's a law that requires doctors to have admitting privileges at local hospitals. Justice Kennedy joined the court's former liberal justices back in 2016 to strike down the Texas law. The Louisiana law is very similar, but the U.S. Court of Appeals for the Fifth Circuit earlier this year upheld the law. So the abortion providers came to the Supreme Court in February asking the justices to block the law from going into effect. They said if the law goes into effect, there's only going to be 1 doctor performing abortions in Louisiana, none after 17 weeks of pregnancy, and if these clinics close, they're likely not going to reopen. And so the Chief Justice John Roberts joined the court's former liberal justices in temporarily blocking the state from enforcing the law, even though he had been in the dissent in the Texas case a couple of years back. So that's kind of a fascinating thing to chew on and think about why he did that. And then there's an Indiana law that requires women who want to have an abortion to have an ultrasound at least 18 hours before they have an abortion. The U.S. Court of Appeals for the Seventh Circuit struck down that law, said that it placed an undue burden, which is the standard for deciding whether or not a restriction on abortion is constitutional, on a woman's right to have an abortion. The argument by the challengers was that many women, there aren't a lot of places where you can get the ultrasounds done, and that many women wouldn't be able to have it done the same day. They'd have to make 2 trips or spend the night. It would make it more difficult for them to have an abortion. So both of those cases were on the Supreme Court's conference today, so we could hear quite soon whether or not the Supreme Court's going to hear oral argument on the merits in those cases.
Thank you for that. John, as you said, you can't predict a decision until you read it, but if the court chooses to hear either the Louisiana or Indiana cases, how do you think the justices might decide it, given the fact that this would be Justice Kavanaugh's first major reproductive rights case, replacing Justice Kennedy?
Well, the Louisiana case is kind of special because it's an awful lot like this Texas case, Whole Women's Health, that they had a few years ago. And so they might feel more constrained to hold in the Louisiana case the way they did in the Texas case, although Justice Kavanaugh has written about why they didn't need to stay the Louisiana case for various technical reasons, but it was a very, in the weeds explanation about why they wouldn't need to have a stay there. But they may feel constrained to rule in a way that lines the Texas case up with the Louisiana one. The fetal, the ultrasound case, because there's not a close analogy on point, they may be kind of more open. But each of these cases, like the undue burden standard, people thought this is the standard that came out of the Casey case from in the 90s. That what is an undue burden, and it's a very open textured test, and there have been opinions over the years that are very different. There was the so-called partial birth abortion case. They had a very they had a very deferential to the legislature opinion in that case, and then in the Whole Women's Health case, they had a much more critical opinion that looked very hard at what at the legislature's judgment on whether they were really justified. And Justice Kennedy authored one opinion, joined the other one, but even though they're very different, they were applying the same test, they were very, very different. And the question is, which test shows up for the ultrasound case? Because if it's the deferential test from the partial birth abortion ban case, that's one answer that the conservatives are going to like. And if it's the Whole Woman's Health, much more, looking critically at what the legislature decided, it's going to be one that's going to please the liberals more. And that's even assuming that it is the undue burden test, because I think the sort of nightmare scenario for people who are on the left of center is, what if the court revisits the undue burden test? We've seen a lot, one of the kind of recurring themes in the last couple of terms is the role of stare decisis, how much you give deference to precedent. And Justice Kagan and Justice Breyer in particular have been criticizing the conservatives for being unduly deferential to precedent. And the reason why they've been doing that is not because they care so much about the cases along the way, although they do, but it's because of what it might mean for Casey and abortion rights.
Thank you for that. Well, it's time for closing arguments in this absolutely fascinating discussion, and I want to ask about unanimity and polarization. Chief Justice Roberts has achieved something in 3 terms that had not been seen since Chief Justice Fred Vinson in 1946, namely 90% unanimity in the court's first 10 decisions of a term. And yet at the end of last term, of course, we did see some high-profile divisions in the census and gerrymandering cases. Given the extraordinarily controversial cases that the court will be hearing this year, ranging from religious freedom to the Second Amendment to LGBT rights to perhaps abortion, do you expect, Amy, to see an effort to achieve consensus and avoid 5-4 splits, especially since we're coming up on an election and we may be seeing a presidential impeachment, or do you expect there to be serious divisions on the cases we've discussed?
Both. I expect there will be an effort, but the Chief Justice is only one vote, and to a certain extent, he is trying to herd cats, at the court. And so I think that particularly with some of these issues that are so important and polarized, that it's going to be impossible to achieve consensus. I know that he would like to live in a world in which people don't think of the court, and that the court, that people don't vote based on the sort of political party of the president who appointed the justices. But I think that's what we're likely to see perhaps in the Title VII cases and in the DACA cases. I think he will work very hard to try to have some consensus. I think that Justices Kagan and Breyer will also work very hard for consensus, because I think that they would rather, as we saw in the Bladensburg Cross case, give a little to avoid a broader result, but that may not be possible.
Many thanks for that. John, your thoughts about whether we are likely to see at the end of this important term more unanimity or more divisiveness, or both?
I hate to be a copycat, but I agree with Amy on this one, because but I do think that there are people who are going to try to achieve unanimity, and both because it decreases, it makes people view the Supreme Court as less of a partisan institution, but also because they think it's better to have opinions with more. You might agree on less, but the agreement that you do have is broader. And as Amy says, Justice Breyer and Justice Kagan work hard for that. The Chief works for that. In the past, Justice Kennedy had worked for that. Justice Kavanaugh, he was, like all the conservatives, he crossed over last term, although in a case without really an ideological valence, an antitrust case. But this is the term where we will be seeing whether he, like Justice Kennedy, for whom he clerked, is one of these people who's trying to work for a consensus in the middle of the court. But there's definitely people who don't even believe that this is a valid enterprise. Justice Scalia criticized the sort of phony consensus building. I get the sense that Justice Gorsuch doesn't have much appetite for it. Agree as much as you can agree, but at that point, these are principles, and you have to, you can't compromise those. But I think that they will try very hard to achieve consensus on things that are, the issues that the justices aren't as rigid on. And it'll be interesting to see. We're figuring out with every vote that Justice Gorsuch and Kavanaugh cast what those issues are.
Thank you so much, Amy Howe and John Elwood, for a fascinating, deep, and illuminating discussion of the important cases on the Supreme Court docket. You have helped us understand these cases, not in political but in constitutional terms, and you have spread constitutional light along the way. Live audience here at the National Constitution Center, please join me in thanking John Elwood and Amy Howe.
That's another episode of SCOTUStalk. Thanks for joining us. Thanks to Casetext, our sponsor, and thanks to our production team, Katie Bart, Cal Goldie, and Edith Roberts.